to cover as much as we can. Always respectful of your time, so I won't belabor a welcome. Thank you for participation. Justice Earls, did you have anything you'd like to say at this time?
Not this morning, thank you.
Okay, all right. So we'll jump right in. So the discussion topics, we'll start with item number 1, asset forfeiture legislation. I think is a continuation. I'll turn it over to Ms. Leslie Dismute.
Good morning, everybody. I'm going to share my screen with you. Again, going back to our recommendations from last time, you'll recall as we left off, and of course, as usual, let me know if I'm for some reason sharing the grocery list with you guys instead of what I need to be sharing. You'll recall we left off talking about asset forfeiture, and Sheriff Ingram had brought up a point about what we locally do in North Carolina or what the state program looks like. And so I did a little bit more digging to get more information just for the good of the group so that everyone can understand kind of what the current lay of the land is with respect to asset forfeiture. While it is technically correct that North Carolina does not have asset forfeiture, an asset forfeiture program, North Carolina does have a drug tax. And what that is it's a statute to you in the pre-work, but essentially it provides for anyone who is caught with a certain amount of controlled substances is if they have not prepaid tax stamps on those controlled substances, then they can be taxed by the Department of Revenue. So for example, if a local agency pulls someone over and they have a kilo of heroin and also $10,000 in their car, then that kilo of heroin can be seized, so can the money, and the heroin can then be taxed. And that occurs through the Department of Revenue. What the local agency has to do is fill out a form called a BD4, and I also sent you a copy of the BD4 in your pre-work. And that basically says, here's how much we seized, here's how much it's worth in terms of what the tax is, and they turn that into the Department of Revenue. The civil side of the enforcement side of the Department of Revenue then comes in and essentially levies that tax. The money that is seized at that point in time with the narcotics goes towards the credit of the tax, and then for any remaining tax that person, DOR calls it literally a taxpayer, owes, they will either garnish a wage or a bank account, or for example, if that person were to get stopped again, maybe a month later with just cash in the car and they still owed a drug tax debt, then that money could be seized in satisfaction of that drug tax debt. That currently is in practice now. It is separate and apart from the federal asset forfeiture. When a local agency completes a BD4 and sends that to revenue, essentially the local agency gets 75% of those profits back to the local agency. The other 25% goes into the North Carolina General Fund. And so it does go back to the agency when there is a drug tax seizure. The main differences, however, are that the federal asset forfeiture program can be used to make seizures when narcotics are not present, and the North Carolina program is tied to the presence of narcotics because it is a tax on the narcotics as opposed to just a seizure of the funds. And so it's not technically asset forfeiture. I think it's worth noting that in the chart that I sent you that lays out the amount of drugs that can be taxed, revenue cannot get involved on a BD4 unless the amounts of drugs are over a certain threshold. And these are all felony amounts. So revenue only gets involved to seize the money and to tax it when there are felony amounts at issue. And so we're talking about folks who are in possession of a felony amount of narcotics are then having to pay a tax on that felony amount of narcotics. So it is completely different than the federal asset forfeiture program. Agencies could participate in both, not in the same case, but could choose which program to participate in, depending on the nature of their seizure. Anything that is seized that is under the threshold for DOR, that is not seized pursuant to federal asset forfeiture, that will just be held, and any money that is seized in one of those cases would go through the criminal process, and then at the end, if convicted, that money would be seized and go to the school board. And so that's the situation under which it would go to the school board, or if a local agency did not complete a BD4 and get revenue involved for any type of felony seizure over the threshold amounts for revenue. So I think that we had some question last time about when the money goes back to agencies, when the money goes to the school board, when the money might go other places. And I hope that this clears that information up so that at least we know what is going on currently in North Carolina when deciding what to do in asset forfeiture. So we left off with the asset forfeiture recommendations. Basically, they are either or recommended solutions for your discussion. We had talked about a seizure of less than a certain amount. I left this in there, even though at the end of the last meeting, my recollection, and someone can correct me if I'm wrong, is that there was not an appetite for putting a cap, because that would not functionally work very well. So I think that I can just take that back out. I didn't want to do that without having the benefit of the discussion of the group. But I think that was where you were all leaning at the end of last meeting, was to not use a cap. So I think the questions for today for discussion are, does the working group want to make a recommendation regarding asset forfeiture? Now understanding how the state drug tax works, which could work in conjunction with or separate and apart from federal asset forfeiture. So with that, I'll turn it over to Mayor Coleman.
Thank you, Ms. Dismukes. I did have a question, as we probably have other questions. What I'm unclear of is if we have any type of change in the to not allow the circumvention of the state law, does that in any way hinder the ability of these federal local task force to have drug cases? And if the federal system chooses to prosecute the case, do they use the federal approach to this seizure, or is that still discretionary?
I'll let you know, in my experience, Mayor Colvin, if the case goes federal, the assets are going to be seized pursuant to federal asset forfeiture. That is typically the way that it happens. Just because, once it is a federal case, it stays with it and uses all of those federal rules. I think that the difference is, in the beginning, when the money is first seized, it's often not clear whether there will be a federal adoption at that point. And so it's not clear whether the case will go federal or whether it will stay with the state.
Okay, so any change to that, how would that impact that fact that you just mentioned? So will it preclude it if the federal, because some of the federal cases are recommended by the local law enforcement, right? They'll send it to them to review. How would any change to that impact that?
So in North Carolina, we have DEA, ATF, FBI, Homeland Security. They all have task force officers, and those officers are all members of the state or local agencies who have been certified as federal task force officers. Now, sometimes it's my understanding that some of the money received from asset forfeiture is used to be able to pay for the ability for those state and local agencies to have task force officers on the federal task forces, which of course increases the manpower of the federal task forces to prosecute federal cases. So that's kind of a rudimentary understanding. In terms of how it affects individual agencies, I would defer to Chief Davis and Sheriff Ingram, who probably have dealt with this within their own agencies.
Chief or Sheriff, can you help us out with that?
Yeah, a lot of the funding that is seized helps to pay for overtime and staffing for the federal task forces. The participation in the various task forces that exist in North Carolina, the incentive for chiefs to even allow officers to participate is that there is no cost to the agency for officers to work with a team of other individuals to tackle some of the larger, more complex kinds of cases that the federal cases are involved in. And I think, taking that funding away takes the incentive away too. I'm already considering moving some of my officers from federal task forces, even though a couple of them have been very beneficial. The other ones that are working on task forces, they're doing more work, for the federal entity than they are for my particular jurisdiction. So that's a consideration that I'm looking at right now. But DEA, FBI, also the ATF task forces. If it weren't for those task forces and the funds that come through those task forces that help us to keep those officers working, the overtime and the cases that they're taking federally, they are dealing with the larger problems, not the cases that we get on the local level, but some that cross jurisdictional lines.
Okay, thank you, Chief. What, Sheriff, any input on that?
Yes, sir. I agree with what Chief said. It would certainly take away the incentive to participate in these federal task force. We have some officers assigned as well, and we have in the past in the various task force groups that are set up. And, I mentioned it the other day on our call. I believe the problem with how we do it has been remedied when they they put the requirement in place that any monies that would be seized and run through the asset forfeiture program had to be connected to a federal case. Prior to that, you didn't have to have a connection to a federal case. And now with that requirement, even though let's just say money, for example, was seized initially, if you cannot make that connection to a case that is ongoing, then you're not going to be able to move forward with that process. And I just think there's no modification needed as with the way we're doing business in North Carolina.
Okay. So just, in other words, if it's not broke, don't fix it. You think that the correction that was made whenever that was changed, took care of the concerns about it. So
Yes, sir, I do. And we haven't had any complaints or concerns. I mentioned that as well the other day. I'd love to have some recent numbers of people complaining and with issues or specific cases where things that were mentioned initially have occurred recently. We haven't had that case in our area, in our jurisdiction. I don't know about the chief, but we certainly haven't. And again, I think that what we have in place now is working, and it's not not used in a manner that would allow for an agency to be asset driven like many were at one time. And so I just feel like this is something that we need to be very careful of, because it could significantly negatively impact our federal task forces that are in place, and the positive outcomes that are happening in the different areas across North Carolina with these federal task forces is just unreal. We're able to get a significant more amount of time for these people that are out on the streets dealing this poison to people and killing them. We're in the midst of a pandemic. We have been for some time, and now we're seeing a resurgence in many areas of our state with regards to opioid-related overdoses. And it's because we have people out there that have demonstrated time and again, they don't care who they kill. They don't care what kind of poison they deal, as long as they're making a profit. And those are the people that we need to get off the street. And the best way to do that in many cases is through the use of partnerships with federal task forces. And so doing this would significantly hurt our ability to operate those task forces.
So only question I have, and I don't want to belabor it, and I guess we'll take a consensus, whether there's a consensus to move this forward or not. What about the part that said that whether they're convicted or not, that the assets are seized if they don't go through the legal process to get it back? How does that work? I know you probably covered a little bit of it, Leslie. We had a lot of information, but that specific point, that if I'm stopped, there's money seized, I'm never convicted of anything in the court of law, do I have to pay an attorney more than what they seized to get my property back?
So I think, Chance, and I was actually going to raise that, but I see Representative Galliard, I think, has joined us now, which is good. I think due process was his concern and what he wanted to talk about with regards to this issue. But I think that we've got two things going on. In the state case, it is a drug tax, not an asset forfeiture. So I think that's a very important distinction. So in the state case, it is possible for the money to be seized and for the tax to be levied without there being an actual conviction, because it could go all the way through to trial. And as we all know, juries do what juries do. That said, the person who is having that drug tax levied is actually in possession of a felony amount of narcotics. So it is as opposed to just being in possession of amount of cash, they're in possession of a felony amount of narcotics if the drug tax is levied. So that's, I think, an important distinction for the state side of things. And then in the federal side of things, you can seize money, and that does not have to go all the way through to trial. If the person does not have to be charged in order to seize $25,000 on the side of the road. Say you could seize that from the person. If the person wants it back and can prove that that money is not the proceeds of illegal activity, they take that proof to the U.S. Attorney's Office, and the U.S. Attorney's Office asset forfeiture section will then process that through. And if they believe it's legitimate, and then they'll do the appropriate paperwork to get that back. There is a form to fill out to initiate that process, and you turn in your proof. Say if you had a receipt, or if you had a bill of sale of your house or a bill of sale of your car or something showing that that's where that money came from, all you would have to do is take that to the U.S. Attorney's Office. The issue that Mr. Abrams raised last week is that there are people who can't figure out how to navigate that process, and so they would have to hire an attorney to do it. I think his point was that it is not it's not a lucrative investment for those attorneys to take on those cases because they don't get paid. And so those people who may want an attorney for that process can't afford to pay an attorney what an attorney would require to be paid in order to handle that case. I'm not sure that that's something the task force can fix, but there is a process that if you take your receipt to the U.S. Attorney's Office, fill out the form, and say this money's legitimate, then that money will be returned to you. That is theoretically how it is supposed to work.
Okay, Representative Galley, are you on? I'd like to hear from you, your opinion.
I am. I'm just trying to get caught up on the conversation, but I'm on. Yes, sir.
All right, we were talking about asset forfeiture. We were trying to see that since this was the first item, if this was something we would move forward or not. The sheriff and chief weighed in from the professional side to talk about how this may impact their ability to work with these federal task force. I know when we talked about it before, a concern that I had, and also you voiced, was that an innocent person's property is seized, and unless they have the resources to get it back, that they're just seized. But I don't know that our task force has the ability to change any federal approach to that. But what do you think about it?
That's what it sounds like to me as well. So I guess we're going to have to address that in another way. I still don't like the fact that an innocent person is taken to task and to have to return their property. I'm listening to Leslie's conversation about providing receipts. I don't know. It could just be me and my poor record keeping. But, if somebody came into my office today and stole my laptop, I think I'd struggle to find my receipt that I purchased it. So that seems really unfair to some innocent people. And I wish there was a way that we could give law enforcement what they need without damaging and hurting innocent people, typically people that don't have the income to be able to protect themselves. And so it feels like a violation to that group of people for me.
Mayor Colvin, may I jump in? Just
I hope you do. You have the law degree, so please.
Well, thank you. I try to respect the work group's process, but I'm just a little confused because I understood there to be several what I would call mid-range recommendations beyond just an all or nothing option. And that the extreme option of not participating at all in the program was not actually what Mr. Abrams was suggesting. He was pointing to the problem of forfeitures of small amounts or seizures of small amounts. Now, whether this is in the state process where technically, where it's different from the federal process, I'd have to go back and review my notes for sure. But he was talking about seizures of small amounts, and I think he was also talking about situations where the person had a defense. I understand, Leslie, what you're saying about, well, they were in possession of drugs, but they had some defense as to why they were in fact not guilty of possessing those drugs. And I thought there were some recommendations that suggested, not having seizures of small amounts where people couldn't defend themselves. And, for a law enforcement agency, $3,000, $5,000 is not a lot, but for an individual family, losing that cash can make a huge difference to them, and they can't afford an attorney or navigate the process to defend themselves.
Okay, and I'm sorry, Miss Leslie also has a law degree. I apologize, but I do recall that that it was kind of small amounts, and I remember that example being used. Is there any common ground that you think we can arrive at, Sheriff and Chief Davis? Any common ground for the small amount seizures, 3,000 to 5,000 or something like that, as they were given those examples?
Mayor, again, I don't have any information that's showing us that this is occurring in North Carolina. I haven't received any information. If I could see that, especially like in the last year or 2 years, that would be very helpful in making a decision.
Well, there was some data that showed, I remember hearing there was like 3 jurisdictions that were responsible for 90%, and it was some amount over $11 million. I mean, seizures are happening. I mean, there's no question they're happening. I don't know if it's as bad a problem as it is in other states. And what, in addition to the small dollar amount, what Representative Galliard and Mayor.
While you can't put any drugs in our hand that day, historical information that we've received through an investigation clearly puts them in possession of large amounts of drugs in the past. And this person is demonstrating a behavior of continuing to be involved in that kind of activity. They just didn't have drugs on them that day. Are we saying that they may have been convicted in the past, or they may be part of an ongoing investigation? That's what is important to look at right now, is when we seize it, it has to be part of an ongoing investigation, a federal investigation, or they will not proceed with the forfeiture process. At one time in the past, it didn't have to be part of an ongoing investigation. And so there was instances where people had money seized that were completely innocent and went through that process. I understand that, but now it's much different with what has been put in place and the requirements with regards to how you move forward with the asset forfeiture process. So it's not like this person is not part of some kind of investigation. I haven't seen that in our area. They have to be a part of some type of federal investigation in order for that to proceed.
So, Leslie, can I get some, I guess I'm confused now, because we get a presentation one week that says something is indeed happening in our state. But now our law enforcement representatives are saying, no, that's not happening in our state. So I want to know if it's happening or not. How do we find out if indeed this issue is happening? Because if I understood Sheriff Ingram, he's saying it doesn't happen.
So I think that they're both right. I know that's not an answer that you probably want to hear. I think to the Attorney General's point, Mr. Abrams presented to us that in the last data that we have aggregated, I believe, is 2016. And in that year, I believe it was $11 million was seized through the federal asset forfeiture program. 97% of that $11 million went to 9 of the North Carolina's law enforcement agencies, of which there are 167. So the point that he was making, I think, is that the federal asset forfeiture program is largely utilized by a small number of agencies in North Carolina, and not the vast majority of our law enforcement agencies. That said, to Sheriff Ingram's point, there was a widespread criticism of the federal asset forfeiture program exactly as Sheriff Ingram noted, when it was not tied to an ongoing federal investigation. And that did happen for years. That's how the program operated. That was a big criticism, but that has now been changed by the federal government so that it has to be tied to an ongoing federal investigation now. And so those incentives for agencies to seize cash to get the percentage back to their agency that some folks perceived to be not the best way to go about things, those incentives don't necessarily exist in the same way that they did previously. So I think that problem has been solved. I think Sheriff Ingram is right about that incentive issue. That doesn't necessarily take care of the due process issue, which is still out there. And that is, as Justice Earls raised, when someone needs to be able to show that the money is legitimate and may need help in that process. And so anecdotally, the white paper that Mr. Abrams provided to us gave examples across the nation where this is happening. And he was talking about how he has had to turn clients away anecdotally for the fact that they need help navigating this process, and it would not be a good investment of his time as a business owner and attorney to take their case, essentially. And so the evidence that he has given us is anecdotal to his practice and based upon what he has spoken with other attorneys about. I don't believe that there are numbers, and I believe it would be very difficult to find those numbers. I think that the only place to get them would be to try to employ the U.S. Attorney's Office to give us those numbers, and I'm not sure that's something that we would be able to get. So I don't know that we are able to get the exact piece of data that I think you're looking for here. I think that what we have is anecdotal evidence about the issue from attorneys' points of views who have been approached by these particular clients, and then anecdotal evidence from the law enforcement side about how things have changed since the law has, or the asset forfeiture rules have been changed by the federal government. I hope that helps. I'm not sure that entirely answers your question.
So a question for you, the Attorney General, the example he gave, so could there be a requirement in North Carolina that once the department received those funds, if certain things, if they were not, if the person was not convicted or what have you, after the federal has finished their course and the assets are turned over, that those departments turn that property back over under certain conditions? Will that violate anything or any requirement? Once the Fed releases that, is there an assurance to them that the department will retain these funds to be used in their operation, or will that impact their agreement with the federal task force?
So North Carolina can absolutely enact an anti-circumvention law. And that would essentially, we cannot be more lenient than the federal government, but we can be more stringent. And so in North Carolina, we can say, you may participate in the federal asset forfeiture program, but only to the extent that you obtain a conviction from that case. If we wanted to say that, we could limit it in that way. Or we could say, as the Attorney General was talking about, you can participate in the federal asset forfeiture program as long as the amount seized is above X amount of dollars. And in deciding X amount of dollars, you have to think, what is that X amount of dollars? For example, the going rate for a kilo of cocaine right now is about $28,000 on the low end. So if someone has $14,000 in cash in their car, that theoretically could be indicative of drug dealing. So is the amount below 14? Is it above 14? That's just as an example of how to consider that number. So we absolutely have the ability in North Carolina to enact a law that would say you can only use the program in this way. We could say you can't use the program, but we could absolutely enact a law that put restrictions on the ability of law enforcement agencies to use it in certain circumstances.
Well, I think what I heard from the chief and the sheriff, I won't put words in their mouth. I think it, and I talked to our chief about it to say, just, hey, how would this impact your ability to do your job? And she kind of gave an example of, maybe a one-time incident where you caught a certain person, let's say with $5,000, but you knew what they were into and they were a part of an overall network of activity. But it was just that particular incident, you caught that. So putting a cap on that amount, it's hard to determine what's a small amount, large amount, or what have you. I would rather, in my opinion, think that it would be more equitable to say that after this person has gone through the court process, and if court of law determines that they haven't done anything wrong, that the department has to turn that back over. I mean, but I'd like to hear from law enforcement and Representative Gallard and the Attorney General or Justice Earls about it as well.
I'll comment. I got off for just a second because I really wanted to sort of run this issue by my coordinator, my task force coordinator, mainly because I wanted to get an idea of what Durham has experienced. I know what Atlanta experienced as it related to large cases, but the scenario you just gave, Mayor Colvin, was exactly what my task force person mentioned to me, that even though they may be investigating a large criminal enterprise, they could pull an individual that's a part of that criminal enterprise over with drugs, with say $10,000-$15,000 in cash with the drugs as well, and that person would be charged. But the case is a much larger case than that individual. And that's the way criminal enterprises work. They're just a bunch of soldiers out there running drugs in and out, of our state. So I don't know that the dollar amount piece serves us well. And really the incentive for the police agency isn't as much the money as it is for us shutting down some of these large operations. It's, even if some years we don't get that much money from asset forfeiture, but we shut down, some of the major drug dealing, gun running, and guns are, a major part of our work right now, especially with the ATF. Last year, we seized over 700 weapons, but we could not have done that if we weren't working on this task force. And, so what I'm saying is whatever we come up with may have sort of a residual impact on the real work of the task forces and whether or not they stay intact.
Absolutely. Sheriff, Representative Gallard, anything? Chief, would your department have a problem with a case that went through the federal system, the person was not convicted, giving that money back?
Not at all. Not at all. If there was some hiccup in a case where we ended up seizing money and we found out that this individual wasn't involved or whatever the case might be, we would not have a problem giving that money back. I don't know what the process is, how often something like that does happen. Many times these large sums of money are seized along with drugs, and they get hit on, when I say hit on, by, being associated with the drugs. So, but no, we wouldn't have a problem with that. I wouldn't have a problem with that language, to tell you the truth.
Representative Gallard.
Yeah, I just, I wouldn't think law enforcement would have a problem with this giving back what was forfeit seized. I thought part of the issue here was that the process that's attached to it is so cumbersome, laborious, confusing, that it requires the innocent person then to spend money to get back their own possessions. And I just don't know how we fix that piece. I mean, and so I'm kind of at a loss how we fix that piece.
So if there were a requirement that if a law enforcement agency participated in the federal seizure program and the person was innocent, then just like a business refunding money that you're not owed, every now and then you audit your books and you say, hey, we're holding $5,000 from John Doe that was exonerated in 2019, and they send him his money back. I mean, does that address the concerns that you have? I agree with you. Shouldn't be an cumbersome process that requires you to have money to go through it. But after you've gone through the legal trial and if the court of law says that you haven't done anything wrong, we should no longer be entitled to keep that money, in my opinion.
Yeah, we're on the same page. Yeah.
And Representative Galliard, to your point, I think that and I've shared two new options here on the screen for y'all to look at. One is putting it at a dollar amount and the other is tying it to a criminal conviction. If you're tying it to a criminal conviction, then I think it solves the due process problem, because if someone is convicted criminally, they are going to have due process within the criminal, within the criminal realm, and therefore they are going to be able to, fix that. And my dog agrees, so that's, but at the same time, if not, then the money would have to go back under this. If they are not convicted, then they would probably have still gotten a lawyer in the course of the criminal case. And if not, then the money would go back to them because it wouldn't result in a criminal conviction anyway. So hopefully that would solve the issue. I think that it's worth noting this number 4 recommendation here indicates that we are making a policy statement here about what it should do without drafting the legislation. I do think the legislation is tricky. One thing to think about in the implementation phase of something like this is, if something is seized pursuant to federal asset forfeiture, how do we get the money back if there is no criminal conviction? And I don't know that there's a good answer to that right now, but that would be something that if we're making this policy statement that we believe this should be the case, the drafters of any legislation would want to figure out what the mechanism would be to ensure that that works.
And I guess I have a question too. Leslie, what is that process now? You know what I mean? If that has happened even today, where a person may have been wrongfully charged or whatever, isn't there a process in place where that individual is entitled to get their money back?
There is, Chief. In the federal system, there's a form that you fill out within a certain time frame, and you provide the proof. I think that Mr. Abrams' point was that it's difficult to figure out how to navigate that for the lay person. It's difficult to figure out, number one, that there is a form. Number two, who do you give the form to? And so folks need to hire attorneys for that process generally. So I think that was the issue. There are specific, and I don't have them off the top of my head, there are very strict time deadlines with all of that as well. So that I think is part of the problem.
Yeah, and I think Sheriff Ingram brought it up earlier. It would be interesting to see just how many cases there are. I don't know of, and that's just my own personal experience. I'm not saying it doesn't happen. It probably does happen. But I don't know of any cases where I had to authorize the return of funds that weren't attached to a criminal case that wasn't successfully prosecuted. But we're on this subject for a reason. So I'm certainly open to whatever recommendations are made, and, for us to be fair to people and ensure that their rights aren't violated. I would like to I would like to know a little bit more about what types of cases other agencies in the state of North Carolina develop that are of smaller amounts of money that come from individuals where that money is taken, as opposed to these large scale investigations that I'm familiar with, and not as familiar with the smaller cases.
All right. Well, so I think, because we have a couple of the items, we'll see if we have a consensus. I guess we can explore a couple options. One, if there's an appetite for a specific dollar amount. Two, the other option I heard was that the agencies, if after the process is over, if the person was found to be innocent or not convicted, that the property would be returned. Or three, to table it until the research information that we've discussed today about how many instances of cases. And
I I don't believe that the research information, I don't believe that we're going to be able to get that information. I think it would require a Freedom of Information Act request to the U.S. Attorney's offices. And then it would also require a survey of all 127 law enforcement agencies and get them to respond. And I don't think that's going to happen before the end of this term of our task force.
Yeah. So maybe, guys, I guess it boils down to if anyone's property, any innocent person's property is kept by a police department or sheriff's department in North Carolina, it's probably one too many if we believe that they shouldn't do that. So maybe we have enough information to base that and to make a recommendation and to kind of move that one forward. But I'd like for us to make some decision on this particular item so we can get to body worn cameras. So I guess, is there those who would favor setting some dollar amount as the threshold for how you use this approach? I think that was option number 2.
Yeah, I prefer option number 3. I can't imagine anyone not being in agreement with option number 3. I mean, we should be able to properly, law enforcement should be able to do their job without innocent people not being protected. So, I mean, I can't imagine, but it sounds like the dollar amount issue is perhaps a little muddy.
Yeah. All right. So, Representative, I take that as a motion for option number 3, or now 2. I think one's been eliminated. So, for the last option, which is, to keep it based on a conviction. So,
that would be my motion. And I do understand that there is some statute language wordsmithing that's going to have to happen. But I do think it's important for us to make sure that anything that we can do to be clear that we want to protect innocent people in the community, that we're willing to do that.
All right. Is there a second on that?
So I guess I want to get the language right. So we're saying that in our federal cases, that the case has to be completely adjudicated with a conviction before any assets are seized or distributed.
Well, Chief, I'm not sure that that's how that would operate. In thinking through it, what might happen is that the money is seized by the federal government, but the North Carolina agencies are prohibited from receiving parts of that seizure. I'm not sure we'll ever be able to tell the federal government to turn the money back if there's no conviction, but it would prohibit agencies from sharing in that seizure, which again provides a disincentive for proceeding in seizures that we aren't going for convictions are. I mean, ultimately, if we're trying to seize money and drugs, it's, as Chief Davis is trying to say, we are trying to take off these large scale organizations and make our community safer. And so if that's what we're trying to do, then hopefully everyone is working towards a conviction for those who are responsible for that conduct. So theoretically, it would disincentivize anyone from trying to seize assets that aren't related to trying to accomplish that goal.
That muddied it up a little bit for me. So I guess the basis was, I don't want to overcomplicate this, but the basis, the way I understood it, was that the federal government seizes it, and at some point they turn it over to the local law enforcement agency or a portion of it. Okay. What I think we're talking about specifically, and what I've heard, is that in the event that local law enforcement receives these dollars, and the person is found to be innocent through the due process of law, that the department will not keep those assets. That was the conversation that I was looking for. So maybe you said that in that, but I saw Sheriff Ingram raising his hand when you were talking. So Sheriff, what do you?
Well, I just wanted to add that my concern is what Mrs. Mukes mentioned earlier with regards to our tax laws, North Carolina tax stamp requirement by Department of Revenue. Under that program, we can seize there's a connection to drugs, whether they were in possession of it or previously in possession of it. There's a connection to it, a certain amount where we can seize under that law. And that person could technically go to court and be found not guilty on a technicality. Not that they're not guilty, but they were found not guilty on a technicality. And that money does not have to be given back. And now we're proposing that under federal law, if they're part of a criminal organization, and that's proven, but for some reason a jury decides to find them not guilty and someone else in the organization guilty, or this person works out some kind of arrangement to testify against a co-defendant, so they're not guilty, they're not found guilty, they're not prosecuted, then this money that is seized, that you can show a clear connection to a criminal organization, just because of this one person was in possession of it. They may be the, as I call it, refer to them as a mule, transporting it from one location to the other. Then that money would have to be given back to that person and ultimately going back into that criminal organization. That concerns me.
Yeah, it concerns me too, because it's not just impacting the little people, the cases with, small folks. This would impact very large scale cases.
So Chief,
yeah,
I'm gonna ask you and Sheriff a question. If two questions, how do you propose the best way from a professional law enforcement standpoint to make sure that you're not taking people who have not been found guilty, who are innocent until proven guilty, taking their property with no process for them to get it back? How do you propose fixing that piece? Because I'm sure we can come up with a number of scenarios that may fit the bill that we probably can't think or talk about or anticipate. So do you think that's fixable? Do you think it's right for a department to keep property even though someone is not found guilty?
I don't think it's ever right. I'm sorry, Chief, go ahead.
I was just gonna say that's a very complicated question. You're absolutely right, Mayor. Representative Gal, you got a very valid point, but my question is are there more cases that would potentially be completely dismantled because we're throwing in this recommendation and really hurt major components of the work that we do, instead of us focus on how do we help that little person? There may need to be something that deals with the little, that individual, and not necessarily the entire, operation of asset forfeiture. Because I have a case right now. I'm going to give you this case. This case right now, truck driver pulled over with a load of drugs and $500,000 in cash. Anytime drugs is associated with the cash is automatically seized. It's dirty cash. It's associated with the drugs. Even if that person that individual gets off on a technicality, then that money goes back into the enterprise. That happens on a regular basis where mules are pulled over, and whether it's $15,000 or $100,000, it's associated with the drug enterprise.
So the tax wouldn't be payable even though he had those drugs in his possession? So the state wouldn't be able to take it under the tax law?
And Leslie, I guess you could probably speak more to that.
You could. So it depends. So if what the chief is talking about is part of a federal task force and they seize the money under federal asset forfeiture, it's going to have to play by those rules. But if it's the Durham Police Department pulling that over, and federal involvement is not there, Durham can then, or whatever agency can BD for it and bring in revenue. the tax will be paid on that load of drugs. The money will be taken in satisfaction for that drug tax. And then 75% of that money goes to the agency, 25% of that money goes to the general fund. But that's, the law enforcement agency has to initiate that process with revenue to get them involved. And if it's federal involvement, then that's going to be different.
So are we looking at maybe applying this recommendation to municipalities as opposed to task forces?
I think this recommendation, Chief, wouldn't change anything with respect to the North Carolina general statute that deals with the drug tax levy. I think that stays the same for cases that are pure state cases. I think that what we are looking at is cases that are seized pursuant to the federal asset forfeiture laws.
Okay.
Chief, what's the hesitation, or not hesitation, but what would be the unintended consequence of putting a very low threshold with a dollar amount, like $5,000? I mean, if the person is not convicted, you receive something and it's up to $5,000, you can do it rather simply, because that's probably a basis to where the cost to get it back will probably not make sense to hire an attorney to get back $5,000 or less.
Yeah.
And that's not a major crime network, or at least that particular seizure. But I don't know, Sheriff, what do you say? I saw you with you.
Has there been any thought, and I don't know the process with, and I'm just throwing this out there, like with the public defender's office, we don't have that in our county, or it's not used a lot. But say with the public defender's office, could there be monies appropriated to provide an indigent person a resource to defend or to represent them through that process if they truly are an innocent person that has money seized from them, to assist them in that matter? Because I think that's the problem we're talking about, is the initial seizure. And even if there was a threshold set on it and it's truly an innocent person, waiting 2, 3, 4 years down the road to get that money back could be a real issue for them, especially if they're indigent and that's all the money they have.
So like legal aid or something?
Sir, I'm sorry.
Like legal aid, you mean?
Yes, sir. I mean, we could solve that problem, because if they truly are innocent and they just don't know how to navigate the process, allocate some monies, because I suspect if it does happen, I don't think it's a widespread issue. And that way it's addressed on the front end, like Representative Gallagher was mentioning.
And I think, Sheriff, to that point, so what we would be talking about, I think that it would be highly unlikely that in a state drug tax case where someone is found to be in possession of a felony amount of drugs, that there would be a scenario where they were not actually charged. So they would get that representation, either they would hire their own or qualify as an indigent for representation throughout the state case. So I think that what we would be talking about is indigent representation in the federal case, which is a little bit tricky in terms of what we would be looking to legislate, is the ability for people to be represented in federal court. I've never looked at the legalities of that. I think we could look into it. If there was a pot of money for it, I'm not sure that would be a problem. I can't think of one off the top of my head, but there may be one. But that would be the thing we would need to make sure that we're thinking about, because this would be us providing a pot of money for people to get their money back in a federal venue. So I think that the state public defender couldn't do it because they wouldn't be practicing in federal court. It would have to be someone who is licensed to practice in federal court. So it wouldn't also be the federal public defender because they are funded it through a different source. So it would have to be private attorneys who are members of the federal bar who are taking on these indigent clients and getting their payment for that case through this mechanism, if that's the way you wanted to go. I think that's how it would end up having to be.
Mayor, I kind of liked where you were going, and I know you have other big stuff you want to get to in this meeting. This is clearly a big issue, complicated issue, not a simple answer. And so I almost think we should have a placeholder recommendation that if the task force were to get behind, it would certainly serve to spark a broader conversation of the relevant stakeholders. And I liked what you were doing where it says if they do not result in a criminal conviction and the dollar amount is $5,000 or less. So that we're talking about a pretty small universe of possible cases. But at least we're putting this out there as something that needs study and that we are concerned about due process. I mean, I hear and agree with everything that the sheriff and the chief have been saying, but my fundamental notions of what it means to be an American, that if government can't come just take your stuff if you're not guilty, and you shouldn't have to jump through 100,000 hoops. And Leslie was just going through all the different craziness you have to do to get a lawyer to do it. So if it's a small dollar amount and you're not convicted, it seems like the state should just give it back to you.
Yeah, and I think, it's kind of a hybrid model is exactly what I was proposing, something that wouldn't impact, giving more fuel to these crime networks, but 5,000 or less. I mean, this is a racial equity task force, so we're talking about those who are disproportionately impacted because of poverty and race a lot of times. So, Sheriff, you and Chief have any issue with those kind of a hybrid version of this, or Representative Gallard?
I don't have an objection. I think we need to put something out there, at least to demonstrate an effort that we aren't trying to marginalize further, individuals who can't defend themselves. But at the same time, not completely take down a system that has worked well really for our communities and some of our indigent communities that are experiencing the amount of crime, gun violence, and drugs. So this isn't an easy cookie cutter approach that we can take with this issue. So I think that's a good start. I would agree.
Sheriff or Representative Gallard, is this something we can get behind as on this as displayed?
Yeah, I mean, I think for me with this issue, something's better than nothing. Because again, I think this is a hard sell that the only way law enforcement can do their job to criminalize guilty people is to penalize innocent people. And I think we've got to change that model. We just can't let that be the case. So, I mean, I think this is some common ground.
Sheriff?
So you're saying set a minimum of $5,000. So you can't
maximum up to 5, 5 or less to handle it this way. I think it's what that said, right?
Dollar amount of seizure is $5,000 or less.
Yeah. Larger amounts may have a little bit more requirements, but this is showing 5,000 or less.
Sheriff, I think the universe of people is anyone who has had up to $5,000 seized and does not get convicted gets their money back. Anyone who had more than $5,000 seized or gets convicted does not get their money back. I think that's the universe that this is saying, with the theory being that folks with over $5,000, hopefully they will get convicted if they are in fact guilty. But if not, then that amount of money is theoretically indicative of a larger scale organization. But folks with $5,000 or less, then there could be different explanations for that money that they have just been unable to provide to the appropriate governmental entity because perhaps they can't afford to hire a lawyer if their last $5,000 was in fact seized. And so the universe of folks is under $5,000. It's probably not the larger scale people. And then if those people with $5,000 or less are not convicted, then certainly they would get their money back.
So who's going to be responsible for returning the 20% that the federal government keeps? Because is that going to put that burden on the local agencies to come up with that as well?
Well, Sheriff, sorry, go ahead.
I wouldn't think you're refunding anything that you didn't receive. I mean,
it only has to be the state agency. Can't be responsible for the feds.
But in that case, if they had $5,000 seized and the federal government went through the process of it and dispersed the 80% to the local agency, they kept their 20%. That person is looking for their $5,000. They're not looking for a percentage. So how do we cross that as well? I mean, I know they were not responsible, but is this going to set a precedence or open up the door for civil suits to make local agencies responsible for that?
I mean, the language.
I don't want to be difficult to get along with it. I'm with you 100%. I don't want innocent people being victimized at all, ever. And that's why our agency has never been asset driven. That's not what it's about. It's what the chief mentioned earlier, is getting these organizations dismantled and the folks involved in them held accountable. But this really concerns me because, again, we're putting information out there and what we feel like we need to do without any supporting data. I don't see any supporting data to say that that's occurring across the state right now. I know that it has without a doubt in the past, but recently with what we are required to do as it currently is.
Well, Sheriff, I'll speak to a couple parts on that. I mean, to me, if it happens once or if it happens 100 times, I think it shouldn't happen if I didn't do anything, and my resources probably shouldn't determine whether I receive my property back. And the second piece is, I don't think we can, the department or the state is responsible for refunding money that they didn't receive. I mean, and I understand what you're saying, that, hey, they got 4,000 or 5,000 back in an 80-20 situation. But I think that's beyond our control. And if they, they need to petition the federal government for the rest of it. I'm just saying that, can you agree that if you're holding $5,000 from someone that was found innocent, should the department keep that?
I can agree if they were found innocent or they're that's such a technical issue, and we have a career prosecutor with us, thankfully, and we know how a CI, a person can become a confidential informant, and how they can get a case dismissed. There's so many variables involved that just because they're found not guilty or the case is dismissed against them doesn't mean that they weren't a part of this criminal organization, or that this money doesn't belong to a criminal organization. And again, I'm not trying to be, I know it sounds like I'm trying to be difficult, but I'm not, because I do not agree with an innocent person being victimized. I do not agree with law enforcement or any other government entity taking anything from people who are innocent. I don't agree with that. Never will. So,
well, I guess, I mean, of course, there'll probably be people who slip through the cracks. And that's just the way that it is with any part of the justice system. You probably have guilty people that are not convicted because of one thing or another. But I'm just saying, this is kind of just a safety net that I think, as you said, we may not have all the details worked out, but a placeholder to say that this is something that we discussed and would like to move forward, and maybe the overall group can weigh in. So do you think we can get a consensus to at least placeholder it and move it forward?
I mean, I just want to add, while Sheriff is thinking through that, I don't know that that we should be communicating that, because it is possible that a guilty person can squeak through, and it is possible, unfortunately, but I don't know that reality should be one that we then say, because a guilty person can squeak through, we're going to also make sure innocent people can't be rightfully dealt with. And I just think that adamantly goes against everything that we believe that is justice. And I don't need data on this because it's just something that should not happen. And so even if I didn't have any data, the reality of it is an innocent person who has their assets seized should have them surrendered. That's just the right thing to do. We don't need data for that. It's just the right thing. And so it's unfortunate that criminals are really good at knowing the law and they figured out ways to circumvent things. But just because that's a reality does not mean innocent people should be caught in the middle of that.
I agree with you.
All right. Well, that sounds like we may have a consensus. Chief, you okay? You were okay a few minutes ago. Did you?
I am not okay, but I'm okay. I think the only reason I'm not okay is not that I don't agree. I think some issues just really require more thought and process. And we're just unfortunately up against a clock with trying to, push out what we hope is going to work and not have some type of, undesirable consequence as a result. I want innocent people not to be, I have relatives and family who have been subjected to having to deal with these kind of situations. Unfortunately, we all do. But I just think, to get this moving, and who knows, maybe we'll have some opportunity to socialize it some more at some point with the larger group. But I agree. We can move forward. I agree with reservation.
You hold your nose and agree. Huh? I got you.
Yeah.
All right. So just for the record, guys, so those who are in favor of moving this forward as presented, understanding that modifications and more discussion is needed. What say you, Chief Davis, with reservations, I guess?
I agree.
All right. Representative Galliard?
Yes, I'm good.
Sheriff?
You can say agree with reservations.
Yes, sir. With strong reservations. Yes, sir.
All right. I agree. Thank you all.
I want
All
to
right.
know that I'm sitting in my office just laughing at you guys in pain. It's very funny.
Well, I will say this, Attorney General, this is very smart to put this diversity on this particular task force.
That's the only way we get good answers, is to have all perspectives heard.
All right.
Yeah.
Body worn cameras, Ms. Dismukes.
Yes, sir. So, sometimes I have drafted proposed recommendations for you all, and sometimes I think there are areas where we just really need to take your input and then draft from that. So recommendation number 1 up at the top, this I did draft because this is parallel to the recommendation you have already passed for civilian review boards. So this basically says that we are going to amend the statute that deals with law enforcement recordings to allow access to those recordings to civilian oversight boards and city, town, and county councils in line with our previously approved recommendation on civilian oversight boards and the changes that we made to the personnel laws. So for example, only registered civilian oversight boards or city, town, county councils may gain access. And we had put a proposal to register those boards in our previous recommendation to the full task force. The statute already states that the documents are not public records or personnel records, so we don't need to include that. And then civilian oversight boards or city, town, county councils may review the recordings, but may not have copies or further release those recordings or the information contained therein. That is consistent, and that's the exact language that I took from our recommendation regarding the personnel laws. So this first recommendation deals with access to the videos by the civilian oversight boards and by the city, town, and county councils who currently don't have access unless they go to the courts and get a court order and go through that process. This would streamline that particular access. So hopefully that recommendation is pretty, and I know this is the kiss of death, uncontroversial, given that we have passed a similar one for the personnel laws. The question number 1, however, asks, should there ever be a critical incident trigger? If you read the pre-work and the staff memo put together by John Paul, it talked a lot about other states who have a critical incident trigger. And if a certain type of incident occurs within a certain number of days, that video should be publicly released? And if so, do we want to have one? Do we want to add that into recommendation 1? When should they be released? If so, what's our time frame, and to whom? And do victims and their families have rights surrounding the release of any of those videos? As it stands right now in recommendation 1, civilian oversight boards and city, town, county councils are getting to view those things. So there is less of an issue from a victim's rights perspective because we're not putting these things on WRAL. If there is a critical incident trigger and they are released more broadly, do we want to build in any victims' rights there? So that's a question for the group. The second question for the group is moving on to when body-worn cameras should be mandated. Should they be mandated? And if so, then let's answer the following questions. I don't know, Mayor Coleman, if you want to talk about the public records aspect of it first, which is recommended solution 1 and question 1, before moving on to questions 2 and 3, which really deal with, do we mandate body-worns? And if so, what are the parameters surrounding that?
I think we need to unpack it. That's a lot. First part of that about who gets to view it and how quickly the videos should be released. Let's hit that first. I do agree. Civilian oversight boards as the governing body, it's always good to see because we have to get out front and explain to the public and assure them that we're being transparent. I want to throw out to the group the discussion about a reasonable amount of time to release the video. Unfortunately, when you see things, picture's worth 1,000 words. If a video is probably worth 10,000. So if you haven't had an opportunity to put that in context, or if there's only a certain snippet released and not the other part, does that inflame a situation before you have an opportunity to actually go through the process, or does withholding it make it worse when the public says, what are they hiding? When can they release it? So I'll throw those questions out there to you guys.
To that point, Mayor Colvin, if I may, the recommendation number 1 does not contain a time frame. So to address that point, the civilian oversight boards and city, town, and county councils would be able to get access to that fairly immediately. Now, they couldn't further release it, say, to the media or to the public, and they couldn't tell them, for example, what the information was contained therein. But in terms of a civilian or a group of citizens who are charged with accountability, they would be able to see that right away. The question here, number 1, should they ever be automatically released, or what about a critical incident trigger? That deals with your question of should those be released more broadly, not just to the civilian oversight boards and city, town, county councils, but should they be released more broadly, like to the media and that kind of thing? And if so, then the question for this group is when?
Yes, ma'am. Sheriff?
I don't think we should go into the area of trying to define when, because every situation is completely different. And that's going to, in some cases, hurt the situation. Some cases, it may help the situation. I think what we have now is a process where we can get authorization to release it when needed, and it's working. I think, you want to add in number 1 up top as far as the recommended solution, as allowing access to that. We've already covered that previously with the public records, but with regard to this, I see no problem adding that in there, but I don't think we should try to define what a trigger is to release it or not. I think we need to be very careful with that because we could cause significant problems in some situations.
Thank you, Sheriff. Chief Davis or Representative?
Yes, I just, I agree. It's hard to put timelines on them because even when you try to get the video footage redacted, and sometimes you have to redact certain parts of video footage and how much video footage. Say, for instance, Raleigh released 500 videos recently. The work that had to be done in order to release those videos with the appropriate redactions, I'm sure it was a heavy lift. It probably took several weeks. The other thing is, I noticed here, do victims and their families, we always take that under consideration as well, especially in very tragic types of situations. I think that's something that probably needs to be taken under consideration, and who makes that decision as far as, the family members that are involved. So I don't know that a timeline is something that, should be placed on, I guess, as reasonable as soon as reasonably possible. I don't know, maybe something generic.
Representative?
I guess I have a question for law enforcement on this. I'm just from as a layman, I always operate that the more information I have, the better off I am. That's just my logic. But it feels like when it comes to video release, that's not the belief. And I'm just trying to understand, if law enforcement has a perspective, community has a perspective, and the data is the data, what is the damage for law enforcement with as quickly as possible giving the community as much data and as much information as possible?
I'd like to speak to that. Well, one of the big issues we see is that there is no single camera angle that tells the complete story. We have seen that time and again, nationwide. And so in a critical incident, it's not always what one camera angle tells. It may be multiple. There may be bystanders that have video that we eventually can get everything together to piece together an accurate account of what happened. But unfortunately, while in some cases it may be very beneficial to release the footage, in other situations, again, it may only tell a very small part of the story, or it may only show one small angle that doesn't really give clear information or clear up what happened. And so I would be very careful in doing anything that could potentially cause more harm than good in the end. But I agree with you, Representative Galliard. I'm one that wants as much information as possible to make a decision. But unfortunately, sometimes that takes a lot of time to put together, and rushing to release something, again, may cause more harm than good.
Is there any appetite or position from law enforcement that would say this is a reasonable time period? I mean, is there a way to put a ceiling on it? Even though I recognize that we can't say it's not smart, because every situation is different, to say it needs to be released in a week or 2 weeks. But is it possible to put a ceiling to say, it should be released by X time frame?
And what are we talking about as far as releasing, in what kind of situations?
My belief would be that in any situation, I mean, again, it goes back to the more data is better, so that people have all the information necessary. And so, from a layperson's perspective, from the community, I think anything law enforcement does should be open to the community being able to know about. I mean, it's public law enforcement, so.
But we're in a lot of private settings. I mean, we're inside people's homes, and that may not be related to the person that this situation occurred with. So there's a lot of potential invasion of privacy. We're also dealing with underaged folks many times. So there's a lot of issues that I think if we get into recommending just releasing footage just to release it, could potentially cause a lot of harm and re-victimize people over and over.
Yeah, and I wasn't
Right.
recommending releasing it just for the sake of releasing it. I'm really addressing the critical issues that are controversial in nature, where there seems to be a tendency to be for the release of the data and the information to be pretty slow moving. That's the piece that I'm trying to address.
And so I'll point you to the staff memo prepared by John Paul and his team that kind of covers what other states do. For example, California requires body-worn footage of a critical incident, and then that is defined to be released, but permits an agency to delay up to 45 days in certain circumstances. Colorado requires that they're released within 21 days when there's a complaint of officer misconduct, and then there are certain parameters put on that for victim family notification and that kind of thing. Minnesota classifies recording documents, documenting an officer discharging a firearm or using force as subject to release, and then of course puts parameters on that. New York City Police Department publicly releases body-worn footage of a critical incident within 30 days, redacted as appropriate to protect confidentiality and privacy interests, and then of course notifications made to those individuals. Also, critical incident is defined by each of those statutes. So in California, it's defined as an incident involving the discharge of a firearm at a person by a peace officer or custodial officer, or an incident in which the use of force by a peace officer or custodial officer against a person resulted in death or great bodily injury. So, you know, that's, I think, what we're considering. I think on the one hand, when we're talking about a timeline to release, we're talking about release to the public, because if adopted, this recommended solution number one would allow for civilian oversight boards and city, town, and county councils to automatically receive them, you know, so that they can consider from an accountability standpoint what is going on, similar to the personnel records and IA files. So that's not really what we would be talking about here. We're talking about the critical incident that would trigger release to the broader public for purposes of accountability and that type of thing. So we could draft a statute that defined what a critical incident was for North Carolina, defined the time frame by which that must be released, and also put parameters on redactions and victim notifications and that kind of thing to put some of those safeguards in there. That is completely a possibility in terms of what the working group wants to do. And that would not affect the recommended solution here, number one. Recommended solution number one deals with civilian oversight boards and city, town, county councils. When we're talking about critical incident release, we're talking about to the broader public, for Representative Gallard's point of more visibility and oversight. So I do think they're two different things. And I'll share that data, that page from the what you have in your pre-work from the staff memo that talks about California, Colorado, Minnesota, New York, and then down here defines critical incidents for each of those entities.
And if I could just jump in very quickly to the points that Representative Gallard and Sheriff Ingram were making in terms of access versus privacy, I think that really underscores sort of what Leslie was just talking about, the interrelated nature of a lot of these issues. So to Sheriff Ingram's point about law enforcement going into private homes and sort of like being in sensitive situations, that, you know, you could deal with that in a number of different ways. You could deal with that by sort of how you redact videos. You could deal with that in terms of who you get access to or how broadly you distribute videos, but you could also deal with that by establishing parameters on when you turn the camera on and off. So, you know, I think it's important to consider all of these issues sort of in an interrelated nature, if that makes sense. But to Leslie's point, I mean, you could definitely draft a statute that deals with all of those things together.
Okay, thank you.
Question, Mayor, if I could,
Yes,
just so
please.
I'm clear, and I maybe, perhaps I should know this, but I don't. Two questions. Are body worn cameras a statewide requirement for every agency? So currently, do we have agencies that don't use them? We do. And is there, for the agencies that require them, is there any type of penalty or discipline connected to when law enforcement is involved in a critical incident, but then did not have the camera actually on?
That's going to be internal, agency by agency, Representative Galliard. And so that's part of the next question to consider is if we want to mandate that all agencies utilize body worn cameras for certain types of officers, so say for patrol or something like that, then there would also be talking about what about the failure to use it and that kind of thing. I think those are all things we would need to cover in that recommendation, because right now it's going to be based on a violation of policy at an agency that has a body worn camera policy.
Okay. Group, Sheriff or Chief Davis, anything to add about the body worn cameras? So as we were trying to unpack that initially, is there a consensus or is it are we comfortable enough making a recommendation that footage should be viewed by the local governing body or oversight board? That didn't seem like anything that we had an issue with. Is that something we can reach an agreement on that portion of it?
Well, define that for me. I mean, is it just anytime they want to just go pull up a record and look at
No,
it?
no. We can put some structure around it if it's a pending complaint or something. You know, we can put structure around it. I think we can put the triggers in there.
I know we just wouldn't have time to be able to accommodate that kind of request. We need to hire about 2 or 3 more people to be able to just keep up with the volume of requests that could potentially happen from just that, number one, which I'm not opposed to them getting it, but I think we need to be very careful how we craft that.
Agree.
What I might suggest, Mayor Colvin, is that if that is the case, right now, the way that the law enforcement agency statute is drafted in North Carolina, it deals with law enforcement reporting. It deals with the release of all law enforcement reportings, no matter what they are. So any person could try to obtain a law enforcement reporting using the process that's in place. This recommendation doesn't disturb that. Someone could still go to a court and get a court order if they wanted to try to do that. This doesn't change that. This just gives access to these entities kind of automatically. So if you were interested in narrowing that scope, I think what you would do is define a critical incident and do that within the statute to say that release is automatically allowed for registered civilian oversight boards and city, town, county councils for a critical incident. And then you would go one further to define what a critical incident is.
So would this mean that the municipality would probably need to change their guidelines anyway as it relates to civilian oversight boards based on what the state is going to recommend? Because right now, the current guidelines here in Durham for the civilian oversight board only allows them to have access to information based on a complainant's appeal. So, you know what I mean?
So Chief, this would override that.
I got
a
you.
state law would then automatically provide more information than whatever is currently being provided.
Okay, gotcha. But and it would have sort of guidelines to what kinds of situations that those requests could be made for. Just getting back to the point that that Sheriff Ingram made, not to just get inundated with requests, because I want to see it, and so there would be guidelines then. Is that right, Leslie?
I think so. I think you would go ahead and define critical incident. California basically limits it to discharge of a firearm at a person by a peace officer, or where there's use of force against a person that resulted in death or great bodily injury. The NYPD defines it as use of force resulting in death or serious injury, or an officer discharges a firearm in such a way that the discharge hits or could hit another. And then, of course, the police commissioner determines that the release will address vast public attention or concern, or will help enforce the law, preserve peace, and maintain public order. That's NYPD policy, so that's a little bit different.
Okay.
So I think that if we're drafting a state law, the first question is, what is the definition of a critical incident?
Gotcha. Thank you.
Okay, so is there consensus that information should be viewed, I guess, with in critical incidents? And I guess we'll define that or can save that for later discussion with the details. Sheriff, how do you feel about that? I think you've given your part. Representative Gallard, were you okay with the local governing body and the oversight board under certain conditions?
Yes.
Chief and Sheriff, y'all okay with that?
Yes, sir.
Yes.
All right. So we'll move that one forward, and we will work toward getting some specifics about definition of critical incidents.
And Mayor, I'll put something here, but I do think we have to define it in order to move it forward, because I think there's going to be a lot of talk about what critical incident means. I also think that informs this first question about whether or not there should be a critical incident trigger. I think my question to the group would be, is a critical incident in your mind one in which a law enforcement officer discharges their weapon? Is it where there's use of force that results in death or great bodily injury? Is it both of those things? Are there any other scenarios that you think include critical incident?
I like those two, Leslie.
Yeah, I think that captures it.
So let me ask you a question in that regard. I like the discharge of weapon or deadly force or what have you. What type of things trigger review board cases? Does it vary by municipality? I know Durham and Charlotte have one. What type of, the officer didn't talk to me right or didn't respect me? Is that a complaint that I file with the review board, or do they have certain triggers for that?
So you're talking about general officer misconduct that wouldn't rise to the level of a critical incident as defined. So if someone were, say, suing the police department or an officer for some kind of misconduct, a member of the public, the enactment of this critical incident trigger and release of recordings would not change their ability to still go through the law enforcement reporting statute right now and apply to a court for a court order. That process would remain intact as it has been for years. And so theoretically, someone could provide that. Now, a judge has to weigh the factors. There are 8 or 10 factors that a judge weighs to determine whether or not that person gets access to that. So that process would still be there for someone who wanted to challenge some action of a law enforcement officer that didn't rise to the level of what we are calling a critical incident.
Okay. All right. And the next question, I guess, is how do we determine when it's released to the media or whomever?
Some of the language that Leslie went over with a few of the other jurisdictions, I don't have a problem with. Most of the time we can work within 30 to 45 days, 45 on incidents that have really required a lot of work in redacting, but I don't think it should be I don't know, Sheriff Ingram, do you think that would be an issue, 30 to 45 days, or what are your thoughts on that?
I'm still not convinced, Chief, that we need to have a trigger. I mean, there's a mechanism for this to get this video as it is. And so why do we want to modify that? Because I can't put a timeline on how long it would take to do in a criminal investigation. And we're talking about potentially releasing evidence before a criminal investigation is complete or an internal investigation. And I just, I would rather put that in a courtroom setting and let the
So,
judge determine as they can currently if that needs to be released.
so
Because
we're saying 30 to 45, or we're saying days from the date of the incident then? Is that what this recommendation is? Okay.
That would be the question, Chief. So the critical incident trigger means we have defined critical incident. One of those things happens. So within 45 days, the law enforcement agency has to release that video subject to redaction, victim notification, etc. So if we put a date on it, that would mean critical incident trigger means releasing to the public. As we have it defined up in the current recommendation, right now, only the civilian oversight boards or city, town, county councils get them. And it's also possible that if we are, not going all the way to release to the public on a critical incident, but this is a significant step forward. If North Carolina has not previously said in this type of scenario, this information goes to civilian oversight boards and city, town, county councils. This is a pretty big release of information comparatively to what our statute currently does. So it could be that we want to release this much now to these groups and then consider having a critical incident trigger to the broader public as we see how this works in practice. That's also, I think, an option.
Sheriff, jump right in, sir.
I did want to mention, I feel like we're putting the cart before the horse here, because currently it's not mandated that everyone have them. And if we put too many requirements in place, and I dare say you'll have a number of agencies that might be wearing them now discontinue their use if it's not required. So I think we need to get past that point first. It's before we start trying to set triggers and everything else with regards to the use of this.
Well, I'll just weigh in and just say, from a community lens, I understand the logic behind that, but I just don't see how agencies would scale that back. That would be a very difficult sell in the community. I just don't see that happening. And I do think that there's a direct link to getting information out quick and there being increased trust and support of law enforcement and greater health or safety for the community. What we don't want is a community to be in an uproar because they're waiting for information that could have been released, nor do we want law enforcement, having to patrol in an environment where there's a community distrust. It just seems like there's a win-win to getting information out as quickly as possible. I don't see the benefit to the community, to the victim, or to law enforcement to just delay getting information out to people. And we see it over and over again. As communities, we all know this we know this just kind of to know this in terms of our human nature. When an individual, us included on this call, when we don't have information, what do? We make it up. And the quicker we can get information to people, the less information people are making up. And so I just don't get the whole fight to hold information. I think we need to be working hard to release information.
And Representative Galliard, I agree with you 100%. We were one of the first agencies to implement a body camera program, and I'm a firm believer in it. It really has helped our agency more times than I can count now. Address situations within the community, things that have occurred. It helps us it's helped us become a more professional agency. So I am a firm believer in it. But I know of large agencies in this state that currently do not have body cameras. And if we don't address that issue, then there's nothing requiring them to participate, and it's not helpful for others. Again, it's not that I don't want to release information. If you pull up anything that we've been involved in, we give more than most agencies. We try to give everything we can because I want the community to understand exactly what's going on when a situation occurs here. I want them to have all the information. But at the same time, we have to be very careful about putting stuff in writing that's going to potentially jeopardize a criminal investigation or an internal investigation. So it's not that I don't want to release it. It's just that we have to be very careful of the parameters that we set and how it may, in most cases, it may not affect us at all. But in that one case that's really critical, it could be a problem. And that's my only fear. It's not that I'm resistant to giving information.
So in those types of situations, is there any flexibility to, where it could potentially jeopardize a criminal investigation or an internal investigation, that there could be some concessions for those cases?
I think, Chief, you could write it how you would want it to be. If the group feels that, okay, we would typically release these critical incident videos within X number of days, unless, and then there could be qualifiers there, unless. Another data point that I would give for the conversation is that from a prosecutor's standpoint, I agree that transparency helps in community relations and making sure that they feel confident in the outcomes. I also worry that if I did really have an officer that I thought I was going to have to prosecute, and I wanted to ensure that I got a conviction of that officer, I would not want the information to be released to the public because of the possibility of taint of the jury pool, and also of, someone might preform an idea. I would worry about that. And so that's just one other data point to think about. If someone has done something bad and needs to be prosecuted for it, want to make sure that can happen too. So it's a balancing, I think, in making sure that you get the outcome you need. But I think that you absolutely can say critical videos of critical incidents will be released within 45 days, unless, and then list. I would also suggest that if you decide to go that route, you would also say subject to redaction and notification to victims who are present in the videos, that kind of thing. You don't want victims' faces out there and that kind of thing. And then you might think about other scenarios, whether it was, certainly a critical incident video is not one that's an interview with a rape victim. So even if someone's wearing a body worn during an interview with a rape victim, that's not going to fall as part of your critical incident. So if you limit it to critical incidents, I think you take care of that set of concerns. That said, there may be a victim in the critical incident video and you would want to redact and make notifications to families and that kind of thing. So you certainly can build it in that way.
Yeah. And I agree with that. And I think that would have been my only concern, maybe tainting a jury pool or something of that nature. But as far as releasing video footage, I agree. We need to be as transparent as possible, as often as we can, but at the same time have, the language that doesn't completely compromise an investigation as well. And I see someone put it in the chat. I want to say it was John Paul, about California policy allows extensions of 45-day time period in specified circumstances. But, and maybe not the extension being days, but it could be the adjudication of a particular case, especially if it's a serious case, like you say, Leslie, if it's, an officer is criminally charged.
While Leslie's typing that, I'm just kind of wondering, to the sheriff's earlier point, that we have larger or some agencies that don't require them. What generally is the objection? Is it financial in nature, or is it just policing philosophy?
I've heard a blend of that. Um, in my experience with speaking with some of the law enforcement agency chiefs and sheriffs, one of the big issues though is funding, and others is just they don't see how it benefits their organization. We had in-car cameras before they even developed the body cameras, and those, while helpful, they didn't help nearly as much as body worn cameras for obvious reasons, because of how, we can go well beyond just the scope of in front of a vehicle or the rear of a vehicle. But I've heard a combination of those.
Is there a an increased administrative cost comparative to how long the camera is actually on?
Yes, sir. And I'm experiencing that right now. We had a limited amount of storage, and so our officers actually have to go in and categorize by parameters we've set up. And if for some reason they miscategorize that, it's automatically deleted in 30 days to be able to save storage. We're in the process of, fortunately, our county has funded our ability to have unlimited storage, but we're in the process of making sure we finalize those contracts. But there's a lot of agencies that their hands are really tied by the amount of storage they have. And then, you have to have people in place to be able to monitor that storage, pull up that data when needed, to, address concerns, or periodically review. We use it as an opportunity for our supervisors to go and just randomly review things to make sure, that people are doing what they need to be doing, and help use that as a training tool if we see issues. But those are real concerns that have to be addressed moving forward, because the last thing you want is to have limited storage like we do, and no criminal charges, no use of force. It's just an encounter to come in to question 30 days down the road, and then your footage is deleted. And that's happened to us. So that's why we're trying to get it in place where we'll have unlimited storage, but still it's and then think about this for a minute. There's some technology out there now that you can set it up to automatically activate the camera in certain situations.
Yeah.
And then there's certain cameras that you can't. They have to manually do that. So think for a minute, one of these very stressful situations where an officer pulls up or pulls a car over, and the person immediately exits the vehicle with a weapon, and they might have just pulled them over for speeding, 65 and a 55. But yet when they pull over, the person exits the vehicle and comes right towards the officer with a weapon. Are they going to take time to turn that camera on, or are they going to try to defend themselves? That's what we're faced with. And we're looking at this technology and how it's advancing, hopefully, where there is even some of this technology where if you draw your weapon, it automatically activates the camera. We don't currently have that system. We'd love to have it, but when you start talking about transitioning 200 body worn cameras, that's extremely expensive. Yeah. And while, we were very fortunate to get in initially on the initial phase of body worn cameras, now as technology is progressing, we're looking at having to spend a tremendous amount on that. And it's a very financial strain for our agency and our county to try to keep pace with that. So I don't mean to ramble on about it, but there's a lot of issues associated with it. And I want to make sure that we can address those as a state moving forward.
Sure. It's helpful.
Thank you, Sheriff. Chief?
I was just gonna say, typically, and I hope we are gonna move forward with the recommendation for all agencies to have the cameras as well, because um, I've overseen the rollout in Atlanta, and then when I got here, I picked up on the rollout of body cameras here in Durham as well. It takes almost 2 years to roll out a body camera program. A lot of people don't realize it takes that long, but it does, to do a pilot, to train the officers on the technology. The RFP process is arduous. Sometimes they go through without a hitch. And sometimes there are all kinds of glitches, even with the RFP process. So I personally believe that body worn cameras need to be utilized by anybody wearing a uniform. The technology that's coming out is excellent technology with 30-second buffers that pick up the 30 seconds before the officer turns the body camera on, which is a critical window. So some of that technology is just really important. Getting out of the car activates some body cameras now. So if the officer forgets, or if, like Sheriff Ingram says, so I think it's important too that we, I guess, get people sort of ready for mandates on body cameras, and they can be thinking about the funding sources too.
Yeah, I'm sure we'll be seeing those requests at the General Assembly.
Mm-hmm.
Yes, sir. We will need a lot of money when we finish this task force process.
Absolutely.
All right. So, Ms. Dismukes, did you need, do we need to agree or adopt these modifications that we've made, or?
I think so. So I think where we are, Mayor Colvin, is as to recommendation number 1, I think everybody was satisfied with that, with the addition of critical incident. So that's something we could vote on and pass today. I've drafted up number 2 in response to the work group's concerns. So recommend amending the statute to specify that police reportings of critical incidents shall be publicly released within X number of days. I think you need to decide on, California uses 45, Colorado uses 21. Trying to quickly look and see what Minnesota uses. So I think, speaking from the standpoint of someone who's had to review critical incidents for prosecution, 21 is really a quick turnaround. So 45 might be more. I think a prosecutor might have more information to make a decision within 45. That's just throwing that out there. And then, of course, release may be extended for up to 1 year if, and I just have suggested language necessary to protect the integrity of an ongoing criminal investigation. We could be more specific than that. There could be very specific parameters. There could be a set of criteria. That's pretty open-ended as it exists right there. And also, who makes that decision is a question. And then, of course, I think these are not really an issue. Any police recording must be redacted to adequately protect victims and privacy interests of innocent bystanders. Individuals who appear in police recordings should be notified of the recording's release at least 10 days prior. And then I threw this one in as well. Drafters should work with victim advocacy groups, because there may be things that we're not thinking of that the victim advocacy groups might really think are important in order to protect victims in the release of these videos. So we would want to make sure I work with them on that in drafting any change to the statute that would affect victims. So I think that if you all want to pick a number of days, and if you're comfortable with this language, you could think about sending these 2 on. And then where we start next Thursday is the simple question, I say simple, should we mandate body worns statewide? And so that would be where we would pick up next week. So I think we could vote on 1 and 2. We certainly can vote on 1. I think we could vote on 2 if you guys want to pick a number of days. Or if you want to not vote on 2, that can be put into next week. And then next week, I think where you pick up is should there be body worns mandated statewide?
Leslie, just a question on number 2. A release may be extended for up to 1 year if necessary to protect the integrity of an ongoing criminal investigation. So say for instance, there's an officer involved shooting in the SBI, not the agency, but the SBI is going to do the investigation. And it may take them a couple of days and they determine criminality in that investigation. So would that investigation still be sort of protected? And I guess it would be protected in the 30-day or 45-day window anyhow, wouldn't it?
I think that's right, Chief. So I think that essentially if you pick 45 days, then that gives the SBI and the prosecutors 45 days to say, okay, we believe there's really some criminal activity here and we need to start moving towards indictment. Of course, indictments are public. So if there's an indictment within that time frame or even just outside that time frame, then I think the public's going to know that the reason why we haven't seen the video is because we've got an indictment.
Okay.
And so I think that that's kind of a dovetail there, and it just allows to protect, protect the jury pool if there is going to be someone charged, an officer charged or something like that.
Leslie, with regards to under number 2, is there any consideration as to maybe taking the 1 year off and maybe put something along the lines of being extended as needed to protect that it may be at the DA's request? They may need it protected longer than a year. I've seen several cases go much longer than that. And so I would just be concerned with that.
Sure, I think that's something that you guys can definitely vote on. I put that in there. That just came out of Colorado's law. That's what they have. So I put the 1 year in there because I was just drafting something as a starting point. I think you can take this time frame out. I think you can make it based on a certain person's determination, like not the law enforcement agency rather, but the DA's determination. I certainly think those are all options for the work group, whatever the will of the work group is.
And definitely that would be, it's still an independent agency. It wouldn't be the law enforcement agency making that determination. But if they needed to extend it to protect the integrity of the criminal case, I think we should take that in consideration.
All right.
So I think upon request of the district attorney, is that what we're saying? Or we're not identifying the individual at this point?
I think that's up to you. I think we can say if requested by the district attorney. In some ways, I don't know whether that would make communities more or less satisfied. In some ways, it takes it out of the law enforcement agency. Right now, the way the statute is written, the decision to release is put on the chief or the sheriff, based on certain criteria that they have to look through. This takes it out of the purview of law enforcement and gives the extension right to the criminal prosecutor. So that certainly is a different entity with perhaps different interests in delaying the release.
Leslie, while folks are thinking about which way they want to go in that, I just would remind us that we have a separate recommendation regarding investigation and prosecution. So we might not want to say the district attorney, we might want to say the prosecuting entity or the investigating entity, whatever the decision is, not say, because it might not be them.
Yeah. And guys, I've got a hard stop. I've got a thing at 1 o'clock at the university that I'll have to make my way. So
I do too. Just as a side note, everyone, my son is being sworn in as an officer in Rocky Mount PD today. So
all right, congratulations.
I'm feeling a little offended by that. I mean, really, Representative Gallagher?
And Brunswick County's hiring all the time.
Congratulations.
That's awesome.
Congratulations.
So Mayor Coleman, do we want to take a vote on number 1? I think maybe the answer might be yes. And then I think if you are all satisfied, do we want to take a vote on number 2 or do you want to leave that till next time?
I'll yield to the consensus. I'm okay with voting on number 1, and I'll defer to the committee on number 2. If you want to talk about it and we spend a little bit more time cleaning that up, we can, or we can vote on it if you're comfortable. So.
I'm okay with number one, but number two, I would like to have a little more time to consider that if everybody's in agreement.
Okay. Chief?
I'm good with number one.
All right, Representative?
I'm good with number one, and we can discuss two next week.
All right, so it sounds like a consensus, Ms. Leslie, on number one. We'll pick it up from here next week.
And so just to forecast for everyone, next week we'll start with the question of should body-worn cameras be mandated? This list of questions is in your pre-work. So I think that's what we're gonna have to ask. If they are going to be mandated, we're gonna have to answer these questions. Who wears them? When should they be worn? When are they turn on? When should they not be worn? You know, should there be penalties for failure to wear? I think all those things have to be addressed if we're gonna go there. And then the other important thing for us to cover next time will be recommendations to the Standards Commission. And this is whether we add use of force requirements for entry into the profession and also for revocation, suspension, or denial of certification. So I think that's another really big, important topic area for us to cover next week. Angela did send the meeting request for everyone for next Thursday. That was not originally on calendars, but given the amount that we still have to cover and the time we've got left, that puts us at next Thursday for the work group meeting. Then we have the overall task force meeting next Friday, the 6th. Then we have the following week, just point that out to make sure I tell you correctly, we have our work group meeting on the 12th. And then we have a full task force meeting again on the 13th. So we're double dipping the next 2 weeks in order to get everything finished. But those should be, the invitations have been sent out and those should be on your calendars. And again, the things that we need to wrap up are body worn cameras and these recommendations to the commissions.
All right. All right, with that, guys, we'll take a motion to adjourn and see you next week.
Motion.
All right. Have a good one.